Hello, you are welcome to Gwungmijana's Legal Discourse on Criminal Law 2 series. Today's video is a continuation video on sexual offenses, rape precisely. In this video, I shall be discussing the second element of rape. Now the next element is absence or lack of consent. So this is also very key. The prosecution must prove that the sexual intercourse was done without the consent of the prosecutrix or the victim, that the prosecutrix did not consent to it. Because if he consent, then there can be no rape. As a volunteer not fit injurier, there can be no wrong done to the consenting. Most thought or offense is usually negatived by consent. So there are some thought or offense that if there consent, then that offense cannot be said to be committed. The same thing with rape. If you consent, then there's no rape. You cannot later turn around to say there was rape when you consented, when it was your choice. So consent, absence of consent is very important. So another important element the prosecution must prove is that there was absence of consent. Now, what is consent? Let's look at the meaning of consent as defined by the Black's Law Dictionary. The Black's Law Dictionary defines consent for us. Please, just a moment, just a minute. Let me find the definition here. Please, just a minute. Consent, where are you? Consent, where are you? Consent, where are you? Okay, it is here. Consent means approval or permission as to some acts. When you agree or give approval or give permission as to some act or purpose. So consenting in the case of it means giving approval or agreeing to it, agreeing to the act of the sexual intercourse, especially given voluntarily by a competent person. And especially consent is approval or permission or agreement that is given voluntarily, when you give it voluntarily. So that is a consent. So the prosecution must prove that there was absence of voluntary agreement by the prosecutor, voluntary permission or voluntary approval for the acts of the sexual intercourse. Is a very important element of the offense. Now, consent can be obtained invalidly. So let's look at some invalid means of obtaining consent for the purpose of the offense of rape. So when consent is gotten by this means, it is no consent and it is invalid. It is invalid. It will not constitute a consent. And those invalid means of obtaining consent are actually outlined under that section 357. And some of the invalid means is when it is obtained by force. So if you obtain consent by force or by means of threats or by intimidation of any kind, those are invalid means of obtaining consent. So if the rape is committed, if you have the carnal knowledge, but the consent is obtained by any of these means, by force, by threats, by intimidation of any kind, or by fear of harm, or by means of false and fraudulent representation as to the nature of the act, or in the case of married woman by personating her husband, all these ones are invalid means of getting consent, and therefore it does not constitute consent. Other invalid means of getting consent is where the consent is obtained by giving the woman liquor. So if you obtain the consent by giving the woman liquor, it is also not a consent as held in arrow against Camplin. Arrow against Camplin. So consent obtained. So there the accused had intercourse with a woman whom he had rendered insensible by giving her liquor in order to excite her. So if you give the prosecutrix or the woman liquor in order to set her so that you can go in, then there's also not there's an invalid consent. Also, consent obtained where the woman is asleep. So if the woman is asleep, yeah, you now come in, you now go and insert with the mindset that he has consented. No, it does not also constitute consent. Thus, in Arrow against Meyers, the accused was convicted for rape for having sexual intercourse with a woman who was asleep. So if the woman is asleep, you cannot say that you have a valid consent. Also, consent where obtained where the girl cannot understand the nature of the act or give informed decision. So if the girl cannot also understand the nature of the acts, maybe because of her age or other circumstance, it is also no consent. And that's what was held in Arrow against Fletcher, where the accused had intercourse with a girl of 13 years but of weak intellect, and it was held that the jury was rightly told that he was guilty if they were satisfied that the girl was incapable of giving consent or exercising the jury if the girl cannot understand the nature of the act, that the jury was right in holding that the accused was guilty. So if the girl cannot give a sound judgment, informed decision, and does not understand truly the nature of the act, then there's also no valid consent. So these are invalid means of obtaining consent. Any consent obtained by this means is invalid. The next question now is, what if the accused believed that the woman was consenting? So what if the accused believed that the woman was actually consenting? Well, there is a decision in that respect, and there is the decision in DPP against Morgan. In DPP against Morgan, where the House of Lords held that if an accused person believed that the woman was consenting, he should not be guilty of rape, even though he had no reasonable ground for his belief. So if the accused believed that, you were consenting according to this decision, then he should not be guilty of rape. And it is submitted that this position can also be valid in Nigeria, where the accused believe that you are consenting. In that regard, the accused can plead mistake of facts, that he mistake the actual facts that you are consenting, whereas you are not consenting. So there's what consent is necessary all about as an element, and those are the two major elements. But if you are actually writing on it and you outline as it was listed in Postal Verse of the State, and then you say that you discuss briefly the two major ones, it will be a better way to present your answer. Now the next heading is persons who are presumed to be incapable of committing rape under the criminal code. So under the criminal code, there are persons that are incapable of committing rape, or that cannot commit rape under the criminal code. So we shall look at these persons that cannot commit the offense of rape. And number one on the list is a male person. By virtue of section 30 of the criminal code, a male person under the age of 12 is incapable of committing rape. There's a presumption, an irrebuttable presumption, that a male person under the age of 12 is incapable of having carnal knowledge. The presumption is irrebuttable, so you cannot dislodge it. No evidence will be allowed to rebut it or to dislodge it. Once it is established that the accused is under the age of 12, then he has no case to answer, because under the law it is impossible. It is legal impossibility. It cannot be possible for him to commit rape. Although that section, there have been a argument that the sections should actually, be critically examined again in view of the happenings these days. So that section left much to be desired. Now, the next category of person that cannot also commit rape under the criminal code is women. So women. So a woman cannot commit rape under the criminal code by virtue of the definition of the offense of rape under the criminal code, that it has to do with carnal knowledge, and carnal knowledge means penetration is complete upon penetration. So because of this element of penetration, then it is not possible for a woman to commit rape, because she cannot penetrate. She does not have the requisite anatomical structure for penetration. So that's why a woman cannot commit rape under the criminal code, unlike under the verb, the violence against person prohibition, where a woman cannot commit rape. But under the criminal code, it cannot commit because of the requirements of penetration, which she does not have the requisite anatomy or structure to penetrate. So a woman cannot. That's why when the presumption under section 30 that provide for the presumption of incapability of committing rape, what was mentioned there is a male, that a male person under the age of 12 cannot commit rape. So if it would have been also be stated whether by using the word a person under the age of 12, which in that case would have would have said it also involve a woman. So a woman cannot. However, a woman can be guilty for the offense of rape under section 7 by aiding. If she aids the offense of rape, she can be charged as a principis criminis, as a party to the offense. And I think there's a case here in that regard, where a woman was actually found guilty of the offense of rape because she assisted her husband in committing the rape. There's a case. I have a case here, please. Just a minute. Let me look for the case here. Oh, I think arrow against something. Well, I can't find the case here, but okay. Arrow against ram. In arrow against ram, a husband, upon the assistance of his wife, ready-made the wife was convicted as a principal offender for her role in the episode. So the wife assisted her husband to rape the maid and was convicted for aiding. So you can see that a woman can become guilty for aiding. Then another person that cannot commit a rape, who the law provide a presumption in his favor that is presumed to be incapable of committing rape, is husband upon his wife. So a husband cannot commit rape upon his wife. However, this presumption is rebuttable. So there is a rebuttable presumption that a husband cannot commit a rape upon his wife. And what is the rationale for this? First, the rationale can be seen in section 6 of the criminal code. The rationale for this for the rule that the husband cannot commit rape upon his wife can be section 6 of the criminal code defines unlawful carnal knowledge. And recall that when we are defining rape under section 357, we say that any person who has unlawful carnal knowledge. And what is unlawful carnal knowledge? Unlawful carnal knowledge means carnal connection which take place otherwise between husband and wife. So carnal knowledge is said to be unlawful if it is not between, by virtue of that section, if it is not between husband and wife. So if it is between husband and wife, then it is not unlawful. And for rape, for there to be the offense of rape, it must be unlawful. Carnal knowledge that is unlawful, that is the one that is not between husband and wife. So by virtue of that provision, then if it is between husband and wife, then the issue of rape cannot arise. That's one of the basis of that rule. Then another basis of the rule or rationale for the rule that husband cannot commit rape upon his wife is that by virtue of their marriage, there is an implied consent by the wife for sexual intercourse. So after coming into a marriage with a man, there is an implied consent to sexual intercourse. One of the incidents of the marriage is that there must be sexual intercourse. So the wife has impliedly, by marrying a man, you have impliedly consent to sexual intercourse. You people have become one body. So a person cannot now commit rape against himself. You people are now one body. Your body now belong to each other. So there is an implied consent. So you cannot be heard. The woman cannot be heard to complain of the offense of rape. And the statement of L in the crown of the common pleas puts this principle succinctly. L in his books history of the pleas of the crown. L in his book history of the pleas of the crown in 1936 puts the statement succinctly thus: the husband cannot be guilty of rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract, the wife had given up herself in this kind unto her husband, which she cannot retract. So you can see by virtue of this statement, once the marriage, then there's also implied consent by the wife, and she cannot retract it. And in Clark's case, this statement by L was accepted by Brian J. So Brian J accepts the statement of the law as made by L. So Brian J accepted the statement in Clark's case. Also, the statement was also confirmed by Linsky J in Arrow against Miller. So in Arrow against Miller, Lisky J confirm the statement of the law by L. Now, as I've said, the presumption is rebuttable, so it can be rebutted. So there can be circumstances where the husband can actually be said to have committed the rape, and the circumstance is revocation of consent. Revocation of consent. So through the law, it is presumed that an husband cannot commit rape, but by further process of law too, consent by the wife can be revoked. And example of circumstances where the consent by the wife can be revoked is by a decree nisi of divorce or nullity. By a decree nisi. So by a decree nisi of divorce or nullity, if the court declare the marriage to be nullity or have given a decree nisi which is not yet absolute, then consent has been revoked in that circumstance. And that's what the court held in Aru against O'Brien. In Aru against O'Brien. Let's hear the court in Aru against O'Brien, what the court stated in Aru against O'Brien. Just a minute, let me see what the court has to say in Aru against O'Brien. Please come out. Aru against O'Brien. Aru against O'Brien. Okay, there, Park J held that a decree nisi of divorce effectively terminated the marriage, and it was possible thereafter for the husband to rape the former wife. So once the court has declared or pronounced a decree nisi of divorce, a decree nisi is the decree that will come before a decree absolute that is lordship held that such decree has terminated marriage, and after such decree have been made, then the husband can be guilty of rape. Also, another circumstance of revocation of consent is if there is judicial separation or order that the wife should no longer be bound to cohabit. So also, if there is a judicial order that the wife and the husband should live separately, or they should no longer stay together or cohabit during that period of the continuance of the order, then the husband can be guilty of the offense of rape, as held in Clark's case, where it was held that Brian J, when accepting a statement, stated as follows: that a statement of law as generally correct, but he held that indictment would lie in that case because the justices had made an order providing that the wife should no longer be bound to cohabit with the accused. So the lordship accepted a statement of law, but held that in this case, because there was an order, then the husband will be liable. Another instance where there will be revocation of consent and the husband can be guilty is where there is an injunction against molestation or an undertaking against the husband to the court not to molest the wife. So if there's an injunction that the husband should not molest the wife, then in that case he can be guilty, and that's what the court stated in Arrow against Steele. The court upheld the same principle where an injunction has been granted to restrain the husband from molesting his wife, or where he has given undertaking to the court not to do so. So if the husband has given undertaking to the court not to do so, then in that case consent has been revoked, and he can then be guilty of rape. Finally, what is the punishment for a person convicted for rape? The punishment for rape is provided under section 358, the preceding section of 357, and it provides any person who commits the offense of rape is liable to imprisonment for life with or without caning. So the punishment is imprisonment for life, and it can be accompanied with caning or without caning. So you can see how serious the offense of rape is. Thank you for watching. Subsequently, I might discuss other sexual offenses. Please subscribe. As I've said, that's what keeps it moving. And see you next time.